case of Shands Teaching Hospital and Clinic, Inc. versus Kimberly Bellotti. I think I pronounced that correctly. You may approach. Council, again, we have allocated 15 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Yes, I'd like to reserve 3 minutes.
So noted, Madam Clerk. You may proceed, Council.
May it please the court, Christine Davis here on behalf of the petitioner, Shands Teaching Hospital. We're here on one discrete issue, whether a patient safety report created by Shands is protected by the broad privilege and confidentiality provisions of the Federal Patient Safety Act, even though the event involved a fall from a visitor in the hospital as opposed to an event involving an actual patient. The document at issue in this case is patient safety work product as defined by the Federal Patient Safety Act.
In fact, that wasn't even an issue, right?
That was not an issue, correct. We have the affidavit of our Director of Patient Safety who made clear that it was created for submission to the Shands Patient Safety Evaluation System, submitted to its patient safety organization, did not fall under any of the exceptions, such as an original medical record, was not created for a separate purpose. No other requirement of state or federal law required it to be reported to any agency. So under this court's recent decision in Tallahassee Memorial Hospital versus Wiles, it would be a patient safety.
So the court's only rationale was it involved a non-patient, right?
Absolutely.
As I read the order.
It was very clear from the court's order and from the hearing transcript that the only reason she denied this was because she believed, without giving any explanation, that the Patient Safety Act applies only to acts involving visitors.
In fact, in the order, if I recall, the trial court stated that the report should not have been submitted to the patient safety organization.
Right, because it didn't involve a patient. And so, of course, nothing in the plain language of the Act limits the scope of the Act to information relating to actual patients. In fact, the Act's express language makes clear that it's intended to broadly capture all reports that could impact patient safety, healthcare outcomes, and healthcare quality. The goals of healthcare quality and healthcare outcomes are different from patient safety. Together, these three goals concern the entire healthcare system, which is exactly what the Federal Patient Safety Act is.
So, in other words, for the sake of argument, or actually based on the court's order, I assume your argument is we should assume that this is obviously a bona fide patient safety work product report, and that wasn't questioned by the trial court, and therefore the only question is whether the federal law does not apply because a hospital prepares a report to protect patients that may relate to an incident involving a visitor.
Correct. That's
it.
And when you look to the language of the Act, as well as the reason that the Act was enacted, it's very clear that was.
But I mean, so for the sake of argument, I mean, your argument is we must assume that the report was prepared to protect patients, in fact.
Yes, because a fall in the hospital, whether it be a visitor or an employee or a patient, can impact patient safety in the long run. You want to capture all of these events.
It almost seems like the logic of the trial court is you have to wait until a patient slips and falls and breaks their hip before you can do a report that's protected under the federal act.
Exactly.
I mean, I don't see any other way to escape that logic.
That is entirely right, and it is completely contrary to the provisions of the Act and the.
That's kind of a borderline absurd interpretation of the act, isn't it?
I'm sorry?
That's a borderline absurd interpretation of the act,
I would
isn't
agree
it?
with that. The court didn't provide any reasoning for why she concluded that it needed to just apply to patients, other than that it had the word patient in the title. And so, as we've set out in our briefs, the act and the intention of the act is clear that it wants to capture near misses, things that don't involve patients, and it wants to
In fact, the whole purpose of the act is to prevent future accidents,
Absolutely. Right. So we submit that for the reasons stated in our brief, that the trial court got it wrong. It's completely contrary to the language of the act, the reason the act was enacted, and that the order should be quashed, and that the trial court should trial court's order should be quashed, and we should not be required to produce the document. If there's no further questions, I'll reserve the remainder of my time.
Thank you, counsel. You may proceed, counsel.
Thank you, Your Honor. May it please this court, my name is Bailey Howard, and I represent the respondent, Kimberly Belot. Your Honors, Ms. Belot asks this court to dismiss the petition because this court lacks jurisdiction to entertain it. But if this court concludes it has jurisdiction to entertain the petition, then the court should still deny relief because the trial court did not depart from any clearly established principle of law in its ruling. To begin with the jurisdictional issue, this court has, Ms. Belot acknowledges, held many times over the past years that a claim of privilege that has been overruled in the trial court is sufficient to establish the irreparable harm prong of a certiorari.
In fact, you stated that in your response.
Yes, Your Honor. And it's a candid acknowledgement that that's the state of the law in the First District. And the occasion that provides this panel of this court with an opportunity to revisit that is the Supreme Court's recent decision in State versus Garcia. Because the reasoning the court adopted in State versus Garcia, and again, to be candid, Your Honors, the Supreme Court did not say, by the way, all these civil cases holding that all privilege claims equal cat out of the bag information are overruled. That question wasn't before the Supreme Court in State versus Garcia. But the question that was before the court in State versus Garcia was whether a claim of a Fifth Amendment privilege and a violation, an alleged violation of Fifth Amendment privilege, something that also cannot be undisclosed once it is disclosed, sufficed to show that there was irreparable harm for certiorari purposes.
In fact, we said that in an opinion that was not cited in Garcia. We addressed a Fifth Amendment privilege and stated that there was not certiorari jurisdiction in this court, that very specific point. But the Fifth Amendment question's different, right?
It's a different privilege that's invoked, Your Honor, yes. But
That's right, because the Fifth Amendment says no one shall be compelled to be a witness against themselves in a criminal case. So the harm doesn't occur in the Fifth Amendment, as I read Garcia and as I read the opinion I wrote, until a person's convicted.
Yes, Your Honor, or compelled to be a witness against themselves in a criminal case.
And that debate remains kind of unanswered. In fact, the federal courts are split on that. But here the harm occurs when the privilege report is disclosed in violation of federal law, right?
Allegedly, Your Honor, yes, it does. And that's the logic this court has followed in its previous, and I
I'm
believe—
not asking about the logic. I'm asking you to answer that question, which is, that's the harm, right? When the privilege is violated. In this context, different than in the Fifth Amendment.
Yes, Your Honor, that's correct. That is the harm that's been alleged here and that's at issue. But where Ms.
So
Belot
the cat out of the bag logic will apply to this case. You agree, in terms of the harm being disclosed prior to a judgment in the case?
I didn't hear the first part of your question, Your Honor.
So
I'm
the
so
cat
sorry.
out of the bag argument will apply to the facts of this case?
No, Your Honor, it would not.
Why not?
Because a cat out of the bag information is not the same, it's not coextensive with the universe of privileged information. Cat out of the bag information is information that derives its utility from not being known, rather than not being used in some subsequent way. Cat out of the bag information is things like trade secrets, the identity of confidential informants, or attorney-client privileged information, or psychotherapist-patient privileged information, things along those lines. Those are things that only have utility, they only have a purpose, they only have use, to the extent they're not generally known. Cat out of the bag information does not mean that it is something that just can't be put back into the bag afterwards. The harm in the certiorari context for cat out of the bag information should be, and again, Ms. Belot candidly acknowledges that this is different from what this court has held on this question in the past. This is based on Garcia providing an opportunity to revisit this. But the cat out of the bag information means something that is inherently harmful once it becomes known. Confidential informants, if their identity becomes known, they tend to be killed. A trade secret, if it's disclosed, it loses all its economic value for the most part. But just the mere violation of a statutory, rule-based, even a constitutional privilege, as the Supreme Court held in State versus Garcia, is not sufficient to establish irreparable harm. Rather, as the court reasoned in Garcia, Courts must look to how that information will then be used. That's the prejudice for certiorari purposes. That's the irreparable harm. If you can't go back and correct that harm, much as you can't stuff a trade secret back into the bag, then that's irreparable harm. But if there's going to be...
But isn't the harm from violating the Patient Safety Quality Improvement Act that if healthcare workers see that if they prepare this report and it's submitted to the hospital and to the Patient Safety Organization, and the hospital is later sued, they're going to be required to submit to discovery, to depositions, to, shall we say, adverse litigation tactics. And therefore, future employees will say, I'm not going to prepare a report. I see there's something wrong here that could harm somebody in the future, but I don't want to be forced to go to a discovery deposition. I don't want to be forced to undergo the stress of adverse litigation. Wasn't that the whole purpose of the Federal Act?
The purpose, that is, I'd say about 70% of the purpose of the Federal Act, Your Honors. The rest of the purpose is to, and I'm being perhaps unnecessarily punctilious here, is to collate that information and use it to improve patient outcomes. But
We'll call it the primary purpose.
yes, Your Honor. But I wouldn't identify that with the same type of harm that cat out of the bag information causes. It's certainly unpleasant and inconvenient to submit to a deposition.
No, my question goes not to the person whose report is prepared and they're required to submit to a deposition and adverse litigation tactics, as unpleasant as those might be. It's the future person who's not going to prepare a report because they saw their coworker prepared a report. They had to go to a discovery deposition. They had to undergo the adverse litigation tactics, maybe even got sued for that matter. And so the next person in line thinks, I'm not going to prepare a report. I'll just remain silent. Whatever happens from this potentially harmful condition for patients is not my problem. Isn't that what's the whole privilege is about?
Yes, Your Honor, and thank you for clarifying. I apologize for
That's okay.
Yes, that is the
I
harm.
follow the logic of your argument. I appreciate the innovative argument based on Garcia, but isn't this more akin then to a trade secret and other types of privileges that have to be protected by interlocutory appeal?
No, Your Honor, and there are two reasons. The first is that that harm is not specific to the, in this case, the petitioner Shands, but it's not specific to the party bringing the privilege claim. That's the harm to the statutory scheme that Congress enacted.
Doesn't Shands have healthcare workers that might be dissuaded from preparing patient safety work product if they see a coworker? A coworker's report is disclosed?
Certainly, Your Honor, but that's not the same as cat out of the bag information. Those are two, it's certainly a statutorily cognizable harm, I could say, but...
Right, it's federal law.
Yes, Your Honor, it is. But it's not the same type of harm that has been traditionally considered and under Garcia, what I would submit respectfully as a shrinking universe of things that should be considered as cat out of the bag harms for certiorari purposes. And the second reason that it's not sufficient to classify as a certiorariable, if I can invent that word, harm, is that it's, even though it's reasonably foreseeable, is still to some degree speculative. It speculates, and admittedly with a reasonable basis, but it does speculate that this incentive will operate in a nefarious way.
Well, then why did the Congress create the privilege in the first place?
Congress is perfectly willing to reasonably foresee those things, and is...
So that's not speculation. That's the whole basis for the privilege, isn't it? I mean, why else would you have a privilege if not to not only protect the person who prepares the report, but provide protections for other healthcare workers to provide reports?
As a prophylaxis, Your Honor, which is Congress's prerogative, but that's not what certiorari is for. Certiorari is not a prophylactic remedy. Certiorari is a remedy for a specific, identifiable, non-speculative harm.
So, well, let's set aside the cat out of the bag thing for a second. If you, let's assume, for the sake of argument, that this is, in fact, patient safety work product. if a trial court orders the disclosure of it, wouldn't that be in violation of federal law if we assume that it is patient safety work product?
Yes, Your Honor. If we make that assumption, then yes, that would violate a federal law.
Well, your whole argument is, I'm sorry, go ahead, Judge.
Well, you don't think that we can review a trial court's order to disclose something in violation of federal law on a cert petition?
Not inherently, Your Honor, no. It would have to cause the particular type of harm that certiorari it recognizes as cognizable.
I was going to ask, again, the trial court's order was based solely on the fact that the person involved here was not a patient. For the sake of this argument, which I appreciate your argument, but your argument is based, it has to be based logically, on the presumption that, yes, it's privileged, yes, the disclosure is going to violate the privilege, and no, there's no remedy for Shands until direct appeal. That's your argument.
Yes, Your Honor, that's my argument.
That wasn't the argument in your response. It's a new argument.
Well, Your Honor, it concerns this court's subject matter jurisdiction, and so it would be raisable at any time. However, I don't quite agree with Your Honor, if I may respectfully disagree on the point that it wasn't raised. That precise contour of it wasn't raised, but Ms. Belot did argue in her response that this court lacked jurisdiction because Shands had not made a particularized showing of any irreparable harm on the record before the court.
But again, logically, again, to an attempt to give your argument its full flavor, if I may, your argument has to be this is a violation of federal law. You have to concede that. You have to concede that it's privileged information, but your entire argument now is it doesn't matter. We don't have subject matter jurisdiction to review this information because Shands has a remedy on direct appeal.
No, Your Honor, that's not the entirety of my argument.
Okay?
Because this has all been about the jurisdictional prong. There is still, however, a merits argument that I could turn to. And that merits argument is that the assertion that Shands makes here, that there is a clearly established principle of law, that anything it puts into the patient safety portal, irrespective of whether that qualifies as patient safety work product under the provisions of the Patient Safety Quality Information Act, is therefore privileged under the PSQIA, is one, not meritorious under the plain language of the statute, but two, it's not supported by a clearly established principle of law.
But that's not really what they're arguing, right? They're arguing more specifically that this particular report does qualify and that it was in fact patient safety work product, and they've outlined the ways in which they believe that, right?
They do, Your Honor.
So it's
yes.
not just that anything can be submitted, it's that this particular one does qualify.
It's that this particular one does qualify, Your Honor, because it was placed into the PSES, into the Patient Safety Evaluation System, that it was created for the purpose of being put into that system, and that it was submitted to the PSO.
Unlike in Charles.
Yes, Your Honor, unlike in Charles. But the requirements of the Act are more than just that. The Patient Safety Quality Information Act also requires that the information be of a particular kind. And the hypothetical...
Counsel, are there penalties or sanctions for violating the confidentiality or privilege provisions of the Act?
Yes, Your Honor, my understanding is there are.
And what are they?
I believe they're monetary penalties, Your Honor. And I think to perhaps prognosticate where Your Honor might be going, those costs would, again, be distinguishable from the type of harms that are traditionally cognizable in certiorari.
Regarding the notice of supplemental authority filed by the petitioner, recent opinion of Titus Memorial Healthcare, Inc. versus Wow, is there anything other than the fact that this case involves a visitor as opposed to a patient to distinguish that case from this case?
There certainly is, Your Honor. Amendment 7 is not at issue in this case. Wiles is primarily discussing the interplay of the Patient Safety Quality Information Act and Article 25, Section 10 of the Florida Constitution. I believe I've got those numbers right, but that's colloquially known as Amendment 7. This case does not involve an Amendment 7 issue, and based on my review of it, there are only really two sentences in Wiles that affect this case, and those are the ones where the court said that this information, because it was submitted to a PSO and was put in the PSES, it's patient safety work product. So the court didn't meaningfully analyze or discuss the issues that are present on the merits in this litigation. And Your Honors, I'll take the last 30 seconds I have here with this court's indulgence and just make one small point about if this court concludes that, that relief is appropriate and that it has jurisdiction, then this court should remand for further fact-finding to determine in an in-camera review of this document, something that has not yet occurred, whether it actually qualifies as patient safety work product. Thank you very much, Your Honors.
Thank you, Counsel. Counsel, regarding the elements of certiorari, the respondent has filed a copy of the Supreme Court's opinion in State versus Garcia as supplemental authority in this case. Can you distinguish the Garcia case?
Absolutely. Garcia dealt with, as Judge Thomas actually distinguished it just a few minutes ago, that dealt with a Fifth Amendment privilege and whether that privilege applied to the cell phone passcode in that case. That has nothing to do with this case. In this case, we have a document that is indisputably patient safety work product that is privileged and confidential under the Patient Safety Act. It satisfies all of the definitions of that. That means it's subject to the broad privilege and confidentiality protections of the Patient Safety Act. And this court in Wiles, the Tallahassee Memorial case, explained exactly why there's irreparable harm, which is consistent with the cases cited in our petition and our response and established throughout the state of Florida that because the trial court's order compels the disclosure of information over a claim of privilege, Tallahassee Memorial has established a sufficient threat of irreparable harm to invoke our jurisdiction. The cases we cited in our brief, similarly, and well established throughout Florida, unlike the case in, unlike the Garcia case, which was completely factually distinguishable, harm resulting from a trial court's departure from the essential requirements of law, which we've established because it's not limited to the Patient Safety Act is not limited to just patient safety events. When it orders a privileged document to be produced, the harm's irreparable because once the information is disclosed, there's no remedy on direct appeal for the production of the privileged information. That's exactly what we have here. And just like in Wiles, we have established the jurisdictional threshold.
Well, and below, was there an argument made by the respondent that this was not patient safety work product? Because the trial court didn't address it.
The only argument was that it's because it involved, well, actually the argument by counsel wasn't as specific as the argument that was raised by the trial court that because it didn't involve a patient, it wasn't patient safety work
Right,
product.
but the trial court made no such finding that I don't think this is patient safety work product because it's an adverse medical incident as required by state law. There's been no argument in this case whatsoever that it meets one of the categories that could present a colorable argument that is excluded under federal law.
Correct. This case is much simpler than the Wiles case because we're not even dealing with Amendment 7. We're not dealing with an adverse medical incident. We're dealing with an incident that relates to a fall from a visitor, which is clearly encompassed
Well,
within the
let me
context.
ask you to address the arguments raised by respondent that there's a smaller universe of protected privileges in light of Garcia than, and I wrote an opinion similar to Garcia, that means we don't have jurisdiction.
Well, it's difficult to
In other words, this is different than trade secret, or it's different than a confidential informant's identity.
I have to admit that I don't fully understand the distinction that's being made between Garcia and with respect to whether it's trade secret or incrimination under the Fifth Amendment privilege. But what I can say is that every single case that we've cited, including this court's decision in Wiles, is clear that if you're compelled to produce a document that's privileged, you don't have a remedy on a direct appeal. That constitutes irreparable harm. And here, if we were required to disclose what is clearly patient safety work product that is protected by the Federal Patient Safety Act, we don't have a remedy on a plenary appeal because CAT is out of the bag.
Well, I think his argument, excuse me, I think the respondent's argument, as I understand it, is, so what? So what that you're required to produce this report, and the person who prepared the report is identified, the report is identified, you go to trial, if you lose a judgment, if I follow the logic, if you suffer an adverse judgment, you can raise the argument on appeal that this document should not have been disclosed, and win a reversal on the basis that you have to have a retrial without introduction of this document. That is the logic of the respondent's argument.
That guts the Patient Safety Act. The whole purpose is to
Well, I
protect.
think respondent's argument is we should just disregard the Patient Safety Quality Improvement Act.
Definitely
I
disagree
mean,
with that.
in terms of let me rephrase that to be more fair. I think the respondent's argument is, for us to have certiorari jurisdiction, we must disregard the federal law.
I don't think that that's correct. I don't think there's any case that supports that. And I think all of the cases that we cite in our briefs that are well established is that when you're required or compelled to produce a privileged document, you don't have a remedy on a direct appeal. I mean, on a plenary appeal. And
So
that's,
you don't think Garcia overruled every single case in the state of Florida that
No.
holds a privileged document required to be disclosed, provides certiorari jurisdiction?
no, nor do I think it could, because it's a completely different issue when you're dealing with a Fifth Amendment testimonial
And
privilege.
why, in your opinion, is that?
Because when you're compelled, for all of the reasons that these cases state, cat out of the bag, when you are compelled to produce a privileged information, you can't call that back. The Federal Patient Safety Act creates these broad confidentiality provisions. If we didn't have a certiorari remedy here, like you said a few minutes ago, it's going to dissuade people from complying with the act. It defeats the entire purpose of the
But
act.
to give credit to the respondent's argument and the logic of it, I think the argument is this. Under Garcia, let's say exactly what happened to Garcia and what happened in the case we had previously addressed. A person is arrested and a detective says, give me your passcode. The argument was that's a violation of the Fifth Amendment. You can't compel a person to provide their phone. Now, they did not quite reach the merits there, but that you can't require a person to provide a passcode to their telephone because that will violate the Fifth Amendment, and that's a terrible thing to violate the Fifth Amendment. And the Supreme Court said, we're not concerned at this point. We don't have certiorari jurisdiction until and unless it's admitted at trial and you're convicted and you raise it on direct appeal.
Well, I believe the court also pointed out that it's not established whether there's actually a privilege that attaches
They
to
did.
that cell phone. And that's very different here from, I mean, opening that can of worms in any case where a trial court requires a party to disclose what is clearly privileged information, and then you're giving it to the other side. There's no reason to call that, I mean, there's no way to call that back.
In fact, I guess, I don't want to be unfair to the respondent's argument. They attempt to define a smaller universe, but it seems to be a universe that has to have some kind of direct, immediate harm. Thus, under their logic, I assume then, for example, disclosing attorney-client confidential communications would not confer certiorari jurisdiction on the court.
Right.
I know he can't stand back up again and disagree, but it seems to be that's the logic
That's
there.
how it follows if you start going down that path. I mean, Garcia is such a distinguishable case, and the issue is distinguishable, and the law of Florida, it did not.
But didn't Garcia have to assume, for the sake of argument, that there was a Fifth Amendment violation?
I don't think it did. I think it said in there that we're not deciding that issue and that there was a question of whether that there was a testimonial privilege relating to
But if there was
giving the
no
passcode.
But if there was no testimonial privilege under the Fifth Amendment in Garcia, well, that answers the certiorari question there, rather than whether there's irreparable harm. In other words, I think the logic of Garcia has to be you assume there's a Fifth Amendment violation. And therefore, does the court have subject matter jurisdiction to cure that error in an interlocutory manner? And the court said no.
The way I read Garcia was that it didn't make that determination. It was almost like it was premature, to decide that at that moment. And so they had to go back and figure that out, but that's completely
So how would
different.
you summarize and crystallize the decision of Garcia?
I would crystallize it as something completely distinguishable from this case. I'm not a Fifth Amendment expert, and I don't pretend to know the circumstances under which a passcode under the Fifth Amendment should be compelled or not. But what I do know is from reading the opinion, it didn't decide the issue. It didn't deal with a cat out of the bag issue as we're dealing with here, and it didn't impact any of the many cases on certiorari being available as a remedy to produce a privileged document. And so I would submit that that case has nothing to do with this case. We have a clear privileged document. It wasn't argued that it wasn't. And if it's compelled to be disclosed, we're irreparably harmed under this court's opinion of this week and under all of the opinions that we've cited and that have been well established in Florida.
In fact, the only reason the court ordered it disclosed is it was a non-patient.
Correct. And as we've said in our brief, that's completely contrary to the purpose of the act, to the provisions of the act, and would basically, convince, if you have to wait for a patient event to happen, it's contrary to everything the act is trying to accomplish. So I would ask that you quash the order. Thank you.
And thank you, counsel, for your respectful oral arguments this afternoon. We are adjourned.
All rise.